Standing means that to bring a lawsuit, the plaintiff must have suffered a harm. And one of the most notorious aspects of PAGA was that an employee or a former employee could sue an employer for violations they didn't even suffer. Under the prior law, a PAGA plaintiff who experienced just a single labor code violation can sue on behalf of every other employee for any other violations of the labor code, even for violations the plaintiff bringing the lawsuit never experienced. The reformed PAGA law is dramatically different than that previous broad standing framework. Now, a plaintiff must personally experience every single violation that he or she is attempting to bring on behalf of other employees. So, for example, previously a plaintiff who experienced only meal break violations could assert and pursue PAGA penalties not only for meal break violations, but for alleged rest break violations, unpaid overtime, and any other labor code violations totally unrelated to meal break uh, periods. Under the amended PAGA law, if the plaintiff only experienced meal break violations, then the plaintiff can only pursue and seek PAGA penalties for claims related to meal breaks. Another part of this amendment is that it clarifies that the statute of limitations on PAGA claims is 1 year, so that the plaintiff must have personally experienced a labor code violation within 1 year prior to the PAGA notice. The impact of this new standing requirement is just huge. I cannot stress it enough. It will have a immediate effect beneficial to employers in newly filed PAGA lawsuits. So first off, what we're going to see is that the scope of the claims will be narrowed. The size of the representative group potentially will be smaller. The discovery process should also be narrowed and more streamlined. And significantly, employers will have more opportunities, especially early on in the case, to get a motion in front of the judge to rule on issues of standing and to narrow the scope of the claims and the discovery. And of course, all of this means that it's going to be less expensive and less time consuming litigation.
And I want to jump in on that too. Recently, we've been seeing a lot of PAGA cases filed where the plaintiff only worked for a couple of days, or even 1 or 2 weeks. And then they were bringing these PAGA cases on behalf of all employees for all wage and hour violations that they could conceivably find for the employer. So this new standing requirement, as Ann mentioned, is big for employers. And if somebody only worked there for a couple of days, they're going to have to show that they suffered the violation that they're trying to bring this on. And if they can show a violation, it's going to be limited just to that violation.
Yes, I can think of at least 2 cases right now off the top of my head where that I'm involved in, where, for example, I think that there was a 3 or 4 day period in which the plaintiff had a recovery period. That's all the time that there was. And so now with this requirement that you have to suffer only that claim that's being alleged in the lawsuit, we're not going to have these expansive lawsuits, expansive discovery proceedings. It's not going to do away with PAGA. We're still going to see these kitchen sink complaints. And what that means is that the defense is going to be going in early on and really strong, and throughout the litigation process, just whittling away chip by chip by chip on everything they possibly can. So a lot of new tools. And even if this standing requirement was the only reform, I think that in and itself is massive.